Hello, and welcome to Encura's Navigating Change conversation series about the changing federal landscape. I'm Kathleen Larmet, Encura's Executive Director, and I'm happy to welcome you to today's program. Joining us today is a returning panel. Please welcome Mindy Pava, a partner at Feldesman Leifler, Ted Waters, Managing Partner at Feldesman, and today's moderator, Dennis Paffrath Nelson, Associate Vice President for Research Administration, Office of the Vice President of Research at Temple University. Welcome back. Today's program is being recorded, so should you need to leave before the end of the hour, know that it'll be posted to the Encura website by the end of this week. And as a reminder, if you have any questions to ask our panelists, you'll see the question mark icon at the bottom of your screen. And now I'll turn this over to Dennis. Dennis?
Hi, we're a little bit early, so I was gonna just hang out for a couple of seconds because we were starting. I want to make sure everybody gets on to be able to listen to the complete session. But I want to welcome everybody who has joined us for this continuing conversation about research administration in a changing landscape. As we know, and you'll find out through this webinar series, that there is a lot of changes that have occurred. Some good news and some even bad news. So I'll turn it over to Ted and let Ted start the series. Ted.
Great. Thanks, Dennis. So I guess I have the first few slides about the really good news from our Supreme Court and a few other things, and then Mindy's gonna kick it off with I think some actually semi-helpful guidance from the administration on DEI front. So here's our information. I've been doing this for way too long, 30 years, and Mindy, do you want to say hello?
Sure. Welcome, everyone. Thanks for joining us this afternoon. As Ted so helpfully introduced me, and Dennis as well, I'm Mindy Pava. Work closely with Ted here at Feldesman, and like many of you, we've had a busy year since January 20th. So eager to dive into today's topics. We have a busy agenda because the news keeps on coming from this administration, and then how it flows down and affects you all as research institutions. So eager to dive in and share, and of course to answer all of Dennis's helpful questions as we get going.
So since we hit the 2 o'clock hour, so we will start with being a law firm. We disclaim everything we say, this is not legal advice, and I know we're going to have a large number of people on the webinar today, but if you have specific facts for your institution and you want to apply the law to those facts, that's legal advice. That's not this. This is our view of current events, of which, as Mindy said, it's only September, but it feels like it's been at least a year, maybe 2 years since this all started. But if you need legal advice, then consult a competent lawyer. That's thing one. Thing two, next slide. These are copyrighted materials for use in your institution. Not that anybody on Instagram would be particularly interested, but please don't post them on the internet. So moving on. So we're going to talk about grants termination case, the Supreme Court's recent decision, as it relates really to jurisdictional questions, which is something most clients never, ever want to hear about. And then briefly comment on the FAIR proposal on indirect cost rates or F&A rates. And then I will do the grant-making executive order from August 7th, which is perhaps a preview of coming attractions. Then Mindy is going to handle the Bondi memo on DEI, other support, training requirements, and certainly Dennis will be peppering us with questions from you all throughout. So we'll try to have an action-packed hour here. And then I think this is, of course, really there's much more to come. So So jurisdiction. So before we get into the exact decision of the Supreme Court, just to give you a backdrop, um, again, these are things lawyers love, probably no one else does, but the question for grant terminations and perhaps for the broader world of federal grants, this is a question that in my opinion, was decided by the Supreme Court 20 years ago, roughly, in this case called Massachusetts versus Bowen. But the question is, which court do you go to when you have a dispute over a federal grant? And I'm not talking about administrative tribunals, NIH. You have what's called the Part 50 process. You have a two-step administrative process for a dispute in an NIH grant. Most other federal agencies, it's one step, but you have to exhaust administrative appeals. That's not what we're talking about. We're talking about actions by the federal government in the case of the American Public Health Association versus NIH to terminate a wide swath of NIH grants for what I think it's fair to say appears to be unlawful reasons, potentially unconstitutional reasons, such as discriminatory actions. And up through Massachusetts versus Bowen, it was always clear that the place to go when grants are being terminated or actions are happening that again could be statutory violations, regulatory violations, such as the uniform guidance, or unconstitutional reasons. And these cases come up once in a while. And again, 30 years I've been doing this, and we always went to federal district court. Now it appears that at least four, perhaps five justices of the Supreme Court say you should go to the Court of Federal Claims. Federal district courts, federal courts of appeals, the Supreme Court are Article 3 courts. That is, they are created by the Constitution, and there's a lot of other complicated issues here, but those courts have both legal powers and equitable powers, so they can order injunctions. They can, as it happened in this case, enjoined the actions of NIH, said these are improper, directed all those awards to be restored. And I think this is what we talked about in our last call, which is, what we want as the grantee world is not money. We want our grants restored. And the Court of Federal Claims is a Article 1 court. In other words, Article 1 of the Constitution is Congress. And COFC, as we call it, was created actually after the Civil War to hear claims for damages. And the classic case was, like the Union Army ran over your cow and there was no way to get paid for your cow unless you went to this thing called the Court of Federal Claims. And there were other reasons that court was created, but it was created to hear claims for damages under a contract or otherwise. And it has, because it's a creation of statute, it's very limited jurisdiction, limited authority or powers. The only power that the Court of Federal Claims has to order injunctive relief is under, for any of you that ever had the wonderful world of the Federal Acquisition Regulation and contracts, they have the rights to order injunctive relief for bid protest, which are challenges to awards of contracts, procurement contracts, which are not grants. And the reason they have that authority, there's something called the Tucker Act, is because Congress said through a statute, the Tucker Act, you have this specific injunctive authority. And why this all matters is, again, we, we don't want money damages for terminating the grants. We want the grant back. Grants, of course, are cost reimbursement instruments. There's no profit that you're losing anyway. And so it's a difficult situation that we're all put into. The court here was a split decision, or called a plurality decision, where four justices said these terminations should all be in the Court of Federal Claims, and you can ask for relief, but again, you're not going to get the relief you want in the Court of Federal Claims. The other four said this is definitely a district court decision. And the thing that crystallizing the whole issue here is that if you go into federal district court and say the government is acting unconstitutionally, then that court should have the ability to order complete relief, as we talk about, which is undoing the damage done by the unlawful actions of the federal government. And Amy Coney Barrett, who was the judge in the middle, said, well, sometimes you have to go to one court for one type of relief and another court for another type of relief. And kind of at the heart of the problem here is that she is saying you can enjoin unlawful guidance, and you can say, you federal government can't do this again. But if you want complete relief, you have to go to the Court of Federal Claims and bring a damages action, but you're never, basically under her view, you're never going to get the grant back. And if we go to the next slide, just really quickly, because we can look at the slides and talk about this, but at the heart of the matter is you can't get the grant back, and the other point here that I think you may have read not to promote the New York Times, but the Daily had a great podcast on the shadow docket. These decisions are all coming out fast and furious. They are not well-reasoned decisions that come from what's called the merit docket. They are coming from the shadow docket, where you have limited briefing, no oral argument. It's actually, I never thought it was supposed to be precedential, but now that at least the block of four, the Supreme Court is saying their decision in the California case is precedential and you have to follow it. And all these cases should be in COFSI. DC Circuit on the environmental justice grants, where they were all terminated, just said you're in the wrong court just a week or so after the Supreme Court decision. So this stuff is really not going to get fixed unless we have good legislation passed by Congress, signed by the president, because what appears to be at least a 5-4 majority of the Supreme Court is going to be forcing a lot of these grant cases into the Court of Federal Claims. So,
and just one addition to that, Ted, and then I'm sure Dennis has some questions on both slides for us. But because this was decided on the emergency, or as Ted put it, shadow docket, it just leaves so many questions unanswered. And one of those is, okay, this NIH case was about grant terminations, which the Supreme Court and the government is saying a termination is a contractual term. So COFSI, Court of Federal Claims, which deals with contracts, this is the correct forum because it's a contractual damages related case. Now you can agree with that or not agree with that, but that was the reasoning. So the question is, okay, if you have a grant related dispute that's not a termination per se, but something like a funding freeze or some other issue relating to your grant, very unclear whether Court of Federal Claims is now the court you go to if it's something that is not a grant termination in the same vein as these NIH terminations were. So because this was decided on an emergency basis without full briefing and oral argument, the vagueness and lack of clarity is just the elephant in the room facing all of us as we grapple with all these issues and try to say, okay, we need relief. What is our forum? What is the best place to go to get this relief and to get these grants up and running as soon as possible? And the answer is that the courts are not providing us with any sort of easy answer on that important question. So Dennis, I don't know if you want to stop here and ask us some questions. We also have a few questions in the Q&A we can get to as
Sure.
well.
So yeah, I'll go to the Q&A first because one just an opinionated answer from you. Do either of you have any faith in the intellectual integrity of the U.S. Supreme Court?
Ooh.
I don't think we're gonna, um, I'm not gonna answer that, Dennis. I don't know,
Okay,
Mindy.
good. Yeah, it's just tough, but it's something to think about. But the more towards the case. So does this mean any injunctions that were granted, are they now overturned? And are there any cases pending in the Court of Federal Claims?
I don't know if there are any yet. That there is one interesting issue I should have mentioned, that for NIH grants, they are under the Department of Health and Human Services. And Part 75 is the uniform guidance for HHS up until next month, literally. And Part 75 does not have this termination for agency priorities that they've been using as justification for a lot of these terminations. And so an intriguing, again, for lawyers, question is if you go to the Court of Federal Claims and file an action, whether you can get what I would call real damages, which are much broader than what you would normally get, both federal contracts and federal grants under the uniform guidance terminations. If it's a proper termination, it then goes into here's what you get. And this is the other problem here. Here's what you get if the government's terminated, you get restitution. So you have to pay severance pay. You maybe have to terminate a lease for a facility. You get legal and accounting costs necessary to wrap this whole thing up and so on and so forth. But it's restitution, not expectancy damages, which is what I would have gotten if I'd had the whole award. And so what I have not seen is anybody try to go to COFC and say, this isn't a termination because you didn't have the authority, so you owe us, some large amount of money. So that would be interesting. I don't know if anybody's going to try that. But so far, there's nothing. The other thing I would say is this EPA case is interesting because the way the Court of Appeals works, you have a three-judge panel. The panel said, "Oh, you're in the wrong court." Our assumption is that the plaintiffs in that case are going to file for what's called an en banc. ENBANC, it's French, I believe, en banc petition to have the whole Court of Appeals hear that case. And that case, assuming it goes to full briefing and argument and everything else, could be that the DC Circuit tries to flesh out some of these concepts and maybe carve out some hope for us, but there's just so much more to come. Yeah.
And my quick answer to that question about are the cases now pending in COFC is that just because the Supreme Court rules that COFC is the correct forum, the parties would still have to refile in COFC. It doesn't get automatically transferred. So the parties that moved to make the grants reissued would have to determine whether COFC is a forum that could provide them with any relief as to what they are seeking. And as Ted said before, COFC doesn't deal with injunctive issues. So the parties, the plaintiffs, might not believe that that's the correct court that could satisfy what they're seeking. Also, the question, does this mean any injunctions that allowed the grants to stay are now overturned. Again, at the district court level, the government would have to take the Supreme Court's opinion and then move to say district court in light of the Supreme Court's guidance. We are now filing a new motion or a new notice. So to answer your question, there's some procedural things that have to happen for all of this to be in the works, but the Supreme Court's decision certainly should be precedential, and we would expect that those grants that were first terminated, then reissued based on the district court's decision most likely would face terminations again following the Supreme Court's decision.
Yeah, so that was my next question. That was that we're all wondering is, we had so many grants the termination rescinded, and now we have anxious principal investigators who are now concerned that their grants are going to be terminated again. And, and so it is a possibility, but at least let me understand. So there is still some process that the administration is going to have to go through before we might see those terminations start happening again?
Well, the process would be another termination letter. It's
Okay.
to challenge it, I think, is what Mindy's talking about. So yeah,
what I was trying to say is just because the Supreme Court issues an opinion, that doesn't mean automatically the grants are re-terminated. It certainly is leaning like it would happen that way, but first, there's some issues to iron out at the district court, and then you have to reissue the termination letter. So the Supreme Court's decision gives you the authority for the terminations to happen, but it's not, okay, the Supreme Court issues this decision from up high, and the next day your grants are terminated. It's usually a few week process for the government to get its house in order and reissue those letters, and perhaps has to make some sort of motion at the district court level to overturn the district court's decision. So it's a administrative type process, but I certainly believe that they view the Supreme Court's decision as a big victory, and that they will move shortly to reissue termination notices on those grants.
Okay. So that's the extent of the questions for this particular section. So
okay,
we can move on.
Let's move on. By the way, and maybe we just live this here in Washington, D.C. I think I assume everybody on the phone knows that the federal fiscal year ends on September 30th. And so there's who knows what's going to happen on October 1, if there'll be a government or what. But there is opportunity in appropriation bills to get some changes. So you don't know. The FAIR proposal is a proposal that was promulgated, if you will, by Koger and a number of other organizations to try to come up with transparency and rationality, and I believe get rid of the terms indirect and F&A rates, and do a 2-year transition period, as we say here. I will say I'm not sure that you really need. There was some discussion about whether you would have legislation, what exactly, how you would do this, amend the uniform guidance. I'm not even sure if you need to amend the uniform guidance, frankly. There's always been a lot of flexibility in the indirect cost regulations. The problem, of course, is you have somebody on the other side trying to push what are indirect costs, which are generally the facility cost, overhead costs, and other necessary costs to run an institution, and try to limit how much the government's going to pay. So where the FAIR proposal is going, I don't know. But again, if we're getting a legislative fix, I hope we can get include some protections beyond indirect. I guess that's about all I would say. So the question, does this have implications for the 15% indirect. I think the fair proposal, the idea is to use the 15% kind of, the 15%, by the way, for anybody that doesn't follow this stuff, is the de minimis rate. The de minimis rate was something that the Office of Management Budget, OMB, came up with the initial issuance of the uniform guidance in 2014. It just went up from 10% to 15%. Nothing in the uniform guidance says what that, and that's true for all indirect. There is no such thing as a set of costs that are specifically indirect. It is what your institution puts in its indirect cost rate proposal to cost allocation services, usually, sometimes DoD. So there isn't this specific set. I think the idea of the fair proposal would be the 15% would be the cap for what I would call classic general administrative costs, and then you would have a research rate or a few different rates depending on the size of the institution. There was a suggestion the smaller institutions could go for a simplified 10% for research plus 15%, so 25%. Percentages, by the way, also don't matter. What matters is the allocation base, what it's applied to. But it gets fairly complicated. And the idea behind the uniform guidance was always they were standards. They aren't a blueprint about how to do something. They're standards to be met. And there's a recognition going back to the dawn of time that there are thousands of different federal grantees, literally tens of thousands. Each one's different. Yeah, how you meet the standards was generally up until now up to you, as long as you can show and defend and create appropriate audit documentation for what you're doing. But anyway.
And I think it's important too that the proposal, the fair proposal, had a 2-year transition period proposed. I think a lot of the drama surrounding the proposed 15% cap was how the agencies rolled it out. I remember the NIH rolled it out on a Friday night and said all future as well as all existing awards starting Monday, 3 days away, and none of those were business days, are now going to be under this 15% cap. And so you have some institutions that have 40, 50, sometimes even 60% indirect cost rates that said, how are we supposed to revise our existing awards? Forget about future awards, which obviously still take planning, but how are we supposed to revise our existing awards on a switch that's happening this quickly? And so that's why some of these cases went to court and injunctions were reached. And now a lot of the 15% has been paused because of the courts and because of injunctions. But with this fair proposal, proposing 2 years, I think is meant to be reasonable and meant to say, okay, Congress and policymakers and university officials and financial officials, we're all going to work together to get our houses in order and try to implement this in a way where we have a ramp up period, and something like this makes sense rather than giving 3 days overnight basically to make such a big important change.
So, a couple of questions. One, with regard to, the injunctions that were put in place, they're still in effect, and the agencies still have to abide by those injunctions. And everybody is still going to be able to charge their negotiated rate if they should have a rate agreement that is existing, correct?
Yeah, it's nothing changes until, as Mindy said, the Supreme Court issues a decision. They were a little miffed, at least the group of 4 that were saying you should go to COFC. They were a little miffed that federal district courts weren't doing what they were told to do. But the way it's supposed to work is if you're in active litigation, and most of these cases, by the way, were preliminary injunctions, they aren't final injunctions, so the case continues while the injunction, what's called preserving the status quo, remains in effect. But you would make a filing with the court saying there's new authority, everything's changed, you should vacate your injunction, and so on and so forth. So there'd be more to come, but in the meantime, it's until it affects your grants, you're proceeding to charge based on your rates or what have you. Yeah.
Right, Dennis, the injunctions in the NIH case, the NSF case relating to the challenging the attempt to impose a 15% cap, those temporary injunctions are still in place. Remains to be seen whether the administration will challenge them. But when you're looking for October 1st and for your next fiscal year, you don't have to put in a 15% rate. Those are enjoined, and this fair proposal is still, they've been presenting it to lawmakers, trying to get support, trying to get the public to back it, but it's still just a proposal. So you should abide by the current terms of your grant and your current indirect cost rate until you are told any different.
So, we've been hearing in the news, or at least I have, discussions where some of the associations that were part of the joint association group creating the FAIR model have requested, Congress to codify this FAIR model into law. What do you think about that particular aspect of this?
Well, I'll give my personal opinion that if there was an opportunity to get a piece of legislation passed, I would not limit it to the fair proposal. I think what all this stuff has shown is that the due process protections for the federal grants world are almost non-existent. And there's bigger fish to fry, frankly. Beyond that, putting the fair proposal, codifying it in statute, it's possible, but difficult because it's so complicated. I mean, I don't know of a part of the US code that is so specific like what they're talking about. Normally, Congress passes laws, even they have broad parameters, but then it's up to the executive branch to pass regulations that would implement and also to administer and enforce. So I think it's a tall order to get something this specific, and yeah.
Okay, maybe we want to move on to the next
Yeah.
next section.
So the next section kind of dovetails, and then we'll on August 7th, the president issued yet another executive order saying that we need to tighten up on federal grants administration. There were several areas. It, of course, reiterated, the various other executive orders on DEI, gender ideology, immigration, and the whole laundry list. But the question, at least in my mind, is this new or not? It included that the administration, and the other thing, just to review the bidding, executive orders are directives to federal administrative agencies to do something. They aren't grant conditions, although they're certainly trying to shoehorn them into grant condition, but they aren't written as if they're grant conditions. They're written as directives to federal agencies. So this one had about four major parts. One is tightening up on drawdown restrictions. So in the grants world, advance payments is the default, which is whether it's the biggest state, state of California, all the way down to the smallest entity, you get money in advance, provided you have financial management systems that can track and account for federal funds, as the term goes. But they've already added a lot more layers of assurance, if you will, in the drawdown system. So I don't know if that's going to be a change. There is also language, getting back to our 15%, is that um, directing agencies to make indirect or an evaluation criteria and making new grant awards. So in other words, if the lower your indirect, the more likely you are to get an award. I have some real questions about the legality of that also, in that grants are generally, again, cost reimbursement instruments or devices. But again, now we don't know which court to go to if we were fighting about this. But that's in there. And then there's two other things. One is that a political appointee or an appointee of a political appointee should approve all notice of funding opportunities, NOFOs, to make sure that any new solicitations for grant awards are consistent with the president's priorities. If that really takes place, you could see a really substantial slowdown in issuing NOFOs for new awards. And then the other one, which again doesn't apply to HHS grants yet, is this concept that is standard operating procedure in the federal procurement world, never been in the part of the grants world until 2020, when the first Trump administration added it to the uniform guidance, which is this concept of termination for convenience. In other words, the government can just say, we don't want to do this grant anymore, we're terminating. That's what we're seeing a lot of. And the Biden administration had a chance to change those rules with the 2024 changes to the uniform guidance. They did not. They changed them a little bit, but basically termination for convenience is full force in effect for all grants, NSF or whatever, except for HHS. They will, for new grant awards after October 1 for HHS, have that termination for convenience language too. So he's really doubling down on termination for convenience, which again, I think is a problem. And what's really behind all this is a real lack of understanding, I'm afraid, in our judicial system, that there is actually something called the Grants and Cooperative Agreements Act from 1977 that made a difference between procurements and
We'll hold its annual meeting in San Marcos,
Well-
Texas on October 19th.
okay. So the Grants and Cooperative Agreements Act, which has kind of been ignored, there's a huge difference, and has been in federal law for a very long time, the difference between procurement contracts and grants and cooperative agreements. But in all cases, last thing I'll say, in all cases, new conditions are supposed to apply prospectively. So you're just like any contract, actually, you have to have consideration. So new rules, changed rules would be either a new grant or a supplement to a grant. And so some of the questions, can we still, at least currently today, we have our grant restored, can we charge, as we always have, appropriate allowable cost? And the answer is yes, as of today, absolutely yes. So,
So a question did come
yeah.
up with regard to it, kind of goes towards these executive orders. Specifically, an audience member wanted to know, how are you advising institutions to manage these new terms and conditions that we are all receiving? For example, compliance with executive orders, basically stating the recipient agrees to comply with the policies and further the objectives set forth in all applicable executive orders currently in legal effect, including those issued on or after January 20th, 2025, as well as executive orders that may be issued after the effective date of this award? Or how are you advising them with, what might be their processes around if they do get after October 1st, these termination for convenience? What are our options?
Well, I'll give you my thought, and Mindy, I'm sure, has better thoughts. But look, you have to, these things like the gender identity executive order, you need to read it. And the question is, are there conditions in there? This kind of nebulous, we're supposed to comply with the spirit of this executive order. That doesn't fly. The question is, what does the executive order say? Gender identity, and we get this question from our healthcare clients all the time. Can we continue to collect SOGI data, which is sexual orientation and gender identity, which has always been a part of a lot of healthcare grant programs? Can you collect the data? I think the answer is yes, because it doesn't say you can't collect data. What it says is you won't promote this gender ideology. So what is promoting? That's what you have to figure out. But I don't think collecting data, I think saying things like, you should think this way or think that way, maybe that is promotion. But each of these executive orders, of which I think there are now 100 plus, um, you know, you got to figure out what it says. Does it actually have some mandate to you? And then what certainly we like here, and I suspect every law firm has the same advice, which is what I call the proverbial memo to file. You've analyzed the issue, you've analyzed the question, you write up your analysis, such as we don't have to do anything or we're not promoting gender ideology, and you put it in the file. And if and when you're audited, you want to be able to say, yeah, we thought about it. Yeah, we analyzed it. Here's our analysis. And, we believe we're compliant.
I agree with that. I think, the memo to file showing that you looked at it carefully and as of this date, again, it should be dated as of September 15th. We've done a programmatic review. Here are our programs. They are not, in our view, they're not violating X, they're not violating Y, they're not violating Z. And then you date it and you sign it, and that memo stays in your file. And if you get audited, you say at the time, we certified and we gave our assurance that we were complying based on our knowledge as of that date. And that's in your file, and you can present that if needed. The other part of that question was the termination for convenience. And that's a much harder, way to give you all a good answer, because if that is fully encompassed into the uniform guidance, and then you start seeing that more and more in your grant terms and conditions, if the government's going to say, like, we have the right to terminate if something no longer effectuates agency priorities, and that termination for convenience is part of your terms and conditions, and you sign your grant and you agree to accept federal funding under that rubric, that's going to be harder to challenge. And what the government is trying to do now under this EO, what they're saying they're going to do is going to be revising the uniform guidance so that that is in their regulations, that they are allowed to move forward and terminate grants that way. So the answer to that is grants are going to be less of a certainty, right? I mean, if you're going to need to work more closely with your financial teams, with your budget teams to say, okay, I have this 3-year grant. I know I'm supposed to be getting $2 million per program period per year on this grant, but in the back of your mind, if you've signed a grant that has terms and conditions that allows the government to terminate for convenience, you have to have long-term planning that says, there is a chance that the government halfway through is going to say, sorry, you're not having this grant anymore. So the clarity that we've had in past years that, okay, we have a 3-year grant, going to have funding coming to us for all 3 years, there's less of a certainty if the terms and conditions are revised to allow termination for convenience.
Yeah, so that's, that answer is, that's the part I think that is scaring a lot of institutions, around tenure and promotion specifically. It's dependent upon, having significant federal funding or funding, research funding. So, that's, I think the current concern right now is that if we have no control over or have that expectation of continuing on with our grants and it just be terminated at some whim of the executive branch to others, it makes it difficult.
Sure. I think that's why you need to look at the guidance that the administration continues to put out about what the administration's priorities are. And in the next slide that we'll get to in a few minutes, we'll talk about DEI and how the government is now trying to offer a little more clarity on what they view to be a legal DEI. And so if you are tracking the government's priorities, which so far, as Ted mentioned, you have all the phrasing around gender and what is promoting gender and gender affirming care. We have DEI, we have the climate change and the EPA grants. You know, I think there needs to be some categorization done if you're doing a programmatic review or an internal review of your grants about which of your grants potentially have the possibility of butting up against those priorities that the government has indicated. And if so, those are the ones that you can say, there is a chance here that this is going to be subject to a termination for convenience clause. Again, the government midstream could think of another priority that we're not anticipating, but to read the tea leaves somewhat and see what have the priorities been and what are the grants with the biggest chance of going into that umbrella and going into that universe of being subject for termination for convenience. Again, it has not even been updated into the uniform guidance yet. So we are still in the very preliminary stages. As Ted said, we're just reading the executive order so far, but the tea leaves are there that this is the way that they are leaning. And so I think doing some sort of programmatic review and seeing which of your grants down the road could be less certain than the normal operating procedure that we've operated under, I think that is an important step to take.
Very good, thank you. So that's all the questions for this particular section. Moving on to the next section.
All right, so I'm gonna start with this, and Ted, of course, can weigh in and happy to answer any questions, but we wanted to switch gears and talk about DEI a little bit, which has been obviously a huge topic in the last 8 months, and give a little credit to the government because on July 29th, a few months ago, they issued a memorandum that really, I think, in one of the first ways was fairly detailed. Again, still not perfect, but fairly detailed in trying to lessen some of the ambiguity over what constitutes illegal DEI. What are these phrases, unlawful discrimination, that we've seen in so many of the executive orders, that we've seen in so many of these big guidance documents coming from the government and being incorporated into your grants under those assurances. What do they mean? You know, if you're doing a certain type of training, is that going to be illegal DEI? You know, very, very unclear and still somewhat unclear, but I think this memorandum is a step in the right direction. It was a 9-page memorandum and it used specific examples to highlight practices that would trigger scrutiny from the government. So I call it like the naughty list and the nice list. And the practices that triggered scrutiny were some things that you would very much normally expect, you know, preferential treatment based on protected characteristics and things like hiring or promotions, facially neutral criteria serving as a proxy for a protected trait. So if you say, I'm recruiting from a certain geographic area, because you're saying, oh, I'm not going to say that I'm recruiting only a certain race because I know that's a protected characteristic, so I'm going to use geography instead, but it's clear that that geography is just a proxy for the trait. That is also going to be on the list that the government is looking at as a process that would trigger scrutiny under their definition of illegal DEI or anti-discrimination. Segregation based on protected traits. There was a whole example of affinity groups that exclude specific individuals, and training programs that stereotype based on protected characteristics. And then the memo ended with a list of best practices, so the government's quote unquote recommendations that are not legally binding, but offer suggestions to help grantees avoid legal risks. So they said, you know, you don't have to do it this way, but if you're doing things like keeping your programs open to all, you know, making sure that you have a legitimate rationale if you are only recruiting in one geographic area. Give me a reason why that geographic area is important to your organization that's not only based on a protected characteristic. So there were lists of, these characteristics, these types of actions will be are under our acceptable list, and these types of actions are under our list that will trigger scrutiny. And why this is important is because you always want to think about the False Claims Act. Think about what the government is going to be investigating through audits and investigations a year or two, maybe only 6 months down the road. And if you are certifying in these terms and conditions that you are not engaging in any of this behavior that the government would view as discriminatory, but in fact you do have programs, or you do some sort of recruiting, or you have affinity groups and you've certified that you don't, that can form the basis of a False Claims Act case against you. And you do not want to be subject to a False Claims Act investigation. And we anticipate that this is going to be the DOJ's new priority. We anticipate many audits and investigations in this field coming up. So I think this guidance document, this memo, is really something that the government will point to, saying you all had knowledge about what was a practice that would trigger scrutiny and you still did it. So therefore, you can't say that you didn't know what illegal DEI was. We spelt it out pretty clearly for you. So this is just, I think, a really important memorandum to look at, to understand, not necessarily to make every single change. Again, it said it's non-binding and only suggestions, but if you're looking at it through the prism of trying to avoid liability on a False Claims Act investigation, I think this memorandum is definitely something to keep on file and to look at your programs, look at your procedures, and say, am I doing anything that's going to put me in line for more risk, or am I doing things that are going to help me mitigate risk? And of course, we want to be on the side that helps to mitigate risk. Ted, I don't know if you have anything to add on this one.
No, it's why I think we're all, I know as lawyers, frustrated with all these jurisdictional issues and other issues. Title VI, for example, of the Civil Rights Act goes to the institution. It is not, even though it's tied to you're covered by Title VI by the receipt of federal funds, but it's your whole organization. Now, if they, which they are doing, saying you're violating federal civil rights laws and therefore violating Title VI, is that supposed to go to the Court of Federal Claims or not? I mean, that's the kind of absurdity. Normally, it would have never been a question. You would have gone to federal district court. But how they enforce this stuff, not clear. But what we said earlier about the memo to file, I'm sorry, it's more work for everybody. And really, the Biden administration did it too. They started tying grant certifications to False Claims Act. And so, the way you protect yourself is, again, you looked at the issue. You are not knowingly lying to the government. That's a false claim, or recklessly, or what's called deliberate ignorance. You, again, have thought about the issue. You've analyzed it. We don't think we're violating, in this case, federal civil rights laws. Put it in the file. And then if you're audited, or investigated, you have what's called a civil investigative demand. You say, yeah, we thought about it and we don't think there's a problem. That makes it very hard for the other side to make a case, as opposed to, that's news to us. So anyway, all right.
So there was a question, there's two questions that were sent in. I think it's interesting that an audience member stated, last week received non-continuation of grant award notices from several Department of Education awards. It notes that the Department of Education determined that continuing the programs is not in the best interest of the government, and they have eliminated 7 ALN programs under Title VI. How do you see this as different, or do you see it as different, since the government is announcing a sweeping elimination of the entire federal programs, not looking at specific awards and their activities, but the entire program itself?
So in the grants world, there's a difference between termination and a non-continuing or not continuing like most grants have 3-year, 5-year project periods or periods of performance, and they have a budget period, and so a non-continue, a non-competing continuation, I'm having trouble speaking today, is when that next budget period gets funded. And I think what they're doing with Ed is just saying, okay, the current grant is over. We're not competing. It raises a number of issues of impoundments and rescissions. The problem, and we have this, and our colleagues here have this in a number of different arenas. The question, and if you look at the statute itself, does it say you get an award, or does it say the administration has to make awards? And so if they have the same pot of money, but now they're going to do a new competition and have new purposes, but maybe still they have to be consistent with the grant statute in the first place. But they have a lot of flexibility about who gets the award, I'm afraid.
And then the final question around NIH's requirement that came out in April, specifically, are the certification statements that we do not operate DE programs still stand? Are they still in effect? They're the NIH requirements. Are you aware of that?
I think that's changed several times, that they had it in the grants and then they've taken it out and then they've had it again. I know that HHS GPS has changed on that, but I would expect the way the government is moving, that if it's not in there now, it will be in there again soon, especially if some of these changes from the last executive order that Ted just spoke about go into effect soon.
I think again, you have to read DEI, and in the Bondi memo, she finally says what I think is actually a more accurate statement of the law, which is you can call it DEI, you can call it the man in the moon. It doesn't matter if you're engaging in discriminatory activity that was unlawful before January 20th, it's unlawful today. The question is, what are you doing? Which I'm sure nobody on the phone has hiring quotas or things that seem to be, among the list of things that they're concerned about. The question is, what are you doing? And from day one, the executive orders actually said you won't have a DEI program that violates federal civil rights laws. So, which is not to say you don't have people in the current administration just going based on words, not deeds. But the Bondi memo, at least, she even says in one of the sections, it doesn't matter what you call it, which is, again, more accurate statement of the law. But
Great.
That was the last question, and I guess we have about 5 minutes, so we should move on to the next topic, so we can get it all into this hour of packed news.
Great, and I'll go through this one pretty quickly. Just wanted to reiterate to all of you that there are some notices going through that talk about trainings, specifically trainings that are now required as you demonstrate the receipt of other support. I think this administration, although we said cares deeply about DEI, gender affirming care, also really interested in where is your money coming from, what if especially foreign entities, and what your disclosures are. So just to keep watching, NIH notices, HHS notices about the trainings that are required for your senior and key personnel on your obligation to disclose the receipt of other support. October 1st, which is just 2 weeks away, is a deadline for all institutions to implement this other support training and also maintain a written and enforced policy. This July notice requiring that these changes be made by October 1st was pretty vague on what the training should entail. And I know that many research institutions have also been implementing research security related trainings. There was a new notice issued just last week changing some of NIH's implementation of research security programs and policies and asking for more certifications by both covered institutions and covered individuals relating to the research security programs. So we've received some questions about, well, can this other support training potentially dovetail with the research security training? I think that's an open question. There are some custom modules that perhaps can align these new NIH requirements with what's already been out there on research security programs. So just keep abreast on what is required on these notices and make sure you're trying to abide as best you can. If something's vague, contact your program officers or contact your organizations or associations, but some of these deadlines are upcoming for these effective dates. So just be aware of that.
And kind of looking at a different notice rather than the new training requirements, specifically the foreign subaward announcement by NIH. There was a question by one of the audience members wondering, does this mean that foreign institutions are no longer eligible to apply as the primary organization? And then alternatively, does it mean that foreign institutions remain eligible to apply as the primary organization for activity codes such as NARL1, rather than the new designation of PF5 and UF5? So it's really around questions of your knowledge about whether foreign institutions are still eligible to submit as a primary organization, or permitting any organizations as collaborators within the application. So they're just asking for any advice, and it's the last question.
Right. So I saw that just came out late Friday from the NIH, the new official guidance on foreign entities. And I saw that it's in the context of subawards. For example, if you are a prime domestic entity applying for a grant and you had a foreign entity as a sub awardee, how you would be allowed or not allowed to submit that application anymore. And it's a whole list of different ways that now you need to categorize the foreign subaward. Basically has to be almost like a separate grant application allowing for the foreign subaward to go through as part of your organization. So it read to me like you can still have a foreign entity apply for a subaward, but it's just going to be a much more burdensome process to do so. I'm not aware of whether that guidance, again, it came out just late Friday and over the weekend, had any effect on a foreign organization applying as a prime. I viewed it as more in the context of this as what would happen if a foreign organization was your subawardee. So I'm not aware of that information, but we can certainly talk to NACURA and your associations and organizations and get back with you on that. But my reading of the NIH notice from, again, very late Friday was it dealt with subawards and not prime awards.
So one last quick question. I missed this one, and so Peter had asked me to make sure I asked this question specifically. Do we know why the Biden administration did not remove the termination for convenience clause in 2024? Has anybody asked that prior administration, specifically, or was there any explanation offered?
I can only give you my cynical DC lawyer answer, which is, people in the government that they don't want to give up control. So the Biden people, they watered it down very slightly, but I mean, I think if you think about it, you're on the other side and you have all these grant programs you're responsible for, and they're troublesome grantees. The process before termination for convenience was you had to show termination for cause. It was a lot of work. And so I think they probably felt it was a good government initiative, frankly.
All right, well, I see Kathleen has popped back on screen, so that must mean our time is up. And so I'll turn it back over to Kathleen.
Thank you, Dennis, and to Mindy and Ted for some interesting and vital information today. For more information on the changing federal landscape, please stop by the NACURA website. Also, information on some upcoming programs. Our Southwestern region will hold its annual meeting in San Marcos, Texas on October 19th through the 22nd. Our Mid-Atlantic region will hold a 2-day virtual annual meeting October 28th through the 29th. And our Western and Rocky Mountain regions will meet November 2nd through the 5th in Costa Mesa, California. And Kira's traveling workshops will be traveling to New Orleans in mid-November for programs on research security and export controls, our ever popular fundamentals #2, and financial research administration. Please stop by our Kira website for information. Thank you for joining us, and we look forward to seeing you next month.